colleagues, it's a pleasure to welcome you to this session, which will be about the issues related to problems related to main issues of nuclear new build projects. And I've had an opportunity to discuss this topic with many of you outside this room, and we're not gonna praise the nucleus today. We're gonna talk about the things and topics that are clear and understandable for everyone, for every person in here. At our last forums, we tried to touch upon some of very specific issues and some very specific problems related to nuclear law, but unfortunately it didn't strike the chord in the hearts of the Russian lawyers. That's why we decided to be closer to people. We decided to be simpler, and today we're going to discuss the topics that everyone, all lawyers, legal advisors, come across when getting to implement large investment projects. We know that investment projects, especially large ones, fail quite often. And in particular when we talk about large infrastructural projects, such as road construction, such as sports facilities construction, and nuclear power station construction. But in this case, nuclear power station is just an example. It's just a symbol of a large investment project, because one block costs about $5 billion. If you build 2 blocks in one station, it's $10 billion right away, so it's a large infrastructural project. And for this, well, to implement this project, there are several approaches available that will allow you to successfully see it through to the end. And it doesn't really matter what kind of project are we talking about, either a stadium or a nuclear power station. A stadium might cost just a little bit less, but the problems still remain the same. And in the course of our today's discussion, we're gonna review some of the key issues that we come across when implementing large-scale infrastructural projects. But we will deal with particular examples in here, particular cases that Rosatom, being a company that actively deals with construction of nuclear power plants abroad, faced and is facing today. In our presentations, we will focus mainly more on the role of the state. So how the state has to be involved in the investment project, how close it has to be involved for this project to be successful, and an interference of a state will be reviewed mainly from the standpoint of financing. So can a large project can be successfully carried out and implemented without the financial support on behalf of the government, any state? Either if the state is a subcontractor or if the state is a customer, main customer. So the question that we are asking, does the financial power that the state possesses have to back up any large-scale projects? And it's not a secret that when it comes to construction of large-scale projects, and construction usually takes not a single day, usually it's years and years, and in the course of this construction we very often come across a situation that the cost of construction significantly grows, and the time for construction usually shifts, and the completion date is usually delayed. There are only a few examples where projects costing a couple of billions of dollars were implemented on time and on budget. So the question comes, who should take the risks? Who should take the risks for an increase in the overall construction budget by 200%? And who should take the risk that instead of 3 or 5 years that you see the construction can last, the construction then goes on for 10, 15, and maybe 20 years? So who is this knight, this brilliant knight on a white stallion who has to secure and ensure the risks of a customer and a subcontractor? And must this hero be the state? Must the state be this hero? And the third thing that we're gonna touch upon in here Yes, and we're more specific now. We'll be talking more about the nuclear energy in this regard. Our industry has many specifics, in particular the recycling and treatment of radioactive materials and wastes, and this business has to be regulated. There have to be rules, and the the states that didn't have anything radioactive apart from tomographies probably in the past, they don't understand how this whole world of nuclear power is built. Do they really need to control the construction, and how they do this? Do they need to interfere? Do they need to correct the project if it comes to a stall? So the question that we're going to take up now is how deep the government shall interfere, and how big the will of the government shall be to resolve various questions during the construction, including changing the legislation. Let me introduce you our first speaker for today, Ahab Abdel Aziz, who is a partner and a director of nuclear energy practice from a consulting company, Gowling Lafleur Henderson LLP. He heads this practice for many years in a row, and I know that Mr. Abdelaziz has a very specific view over the problem of state participating in implementation of large-scale infrastructure projects. I hope that he will share this view to us right now. Please, the floor is yours.
Thank you very much, Mr. Popov, and thank you for inviting me to this prestigious event. I'm delighted to be here. Let me start by telling you what I'm talking about and why I'm going to talk about it. Our job as lawyers often involves us drafting contracts, putting together legislation at the instruction of clients, but I think we do our job best when we can offer insights as consultants who are experts in the particular risks that our clients face. And so today I'll be speaking a bit more about the risks than I'll be speaking about the legal practice. What is the risk and what is the source of the risk in nuclear power projects? And then I'll look at three models for state engagement with that risk. Some have worked, some not have worked. To put the picture in perspective for you as to why this is an important juncture in history for us to be talking about it, you should consider this. There are about 435 operable nuclear reactors in the world today. Every one of those has been built in one fashion or another with the backing of a state, whether it's the state of the vendor nation or the state of the purchasing entity. There's always been a state involved. Today we have 70 reactors under construction in the world. We have something like 160 planned reactors and something in the order of 320 proposed reactors. There is every indication that both because of urbanization, population pressures on the one hand, and climate change imperatives on the other, that the nuclear solution will continue to be an increasingly relevant one. There are certainly many nations in the world that are putting up their hands to say, me too, please, I would like to get nuclear power reactors. The difficulty emerges that the majority of the nations that are slated to get nuclear power in the future, or those who want it, are emerging economies. They face limitations. They face limitations on debt to GDP ratios, conditions that are imposed by the IMF, lack of support from multilateral organizations like the World Bank and other development banks. And so when they come to facing not only the financial investment problem in a nuclear power plant that is worth billions of dollars, but also the capacity to absorb and back up the risk. They have adopted what has really become a Western approach to nuclear power, which is to say, let's keep the government out of it and let's get either the vendors or private capital to back this. That's a very difficult proposition. It's not one that I have yet seen succeed. And I will start my presentation by speaking with you about something that's got nothing to do with the law. So what we're looking at here is, and if you'll pardon me, I'll stand up and you'll tell me if you can hear me, because I have to point. Can you hear me all right?
So we've got problems with translation, so you should speak into microphone.
Okay, yes? Okay, we have a chart that shows you a comparison between the levelized cost of electricity. Thank you. The levelized cost of electricity between different fuels. So nuclear, coal, gas, and onshore wind, and it does it in different geographies. So we're looking at Asia Pacific, Europe, and North America. And we've got a few observations to share with you here. We're going to look at a comparison of the levelized cost of electricity of nuclear across world regions. We'll notice that nuclear levelized cost of electricity, the midpoint in North America, doesn't cost the same everywhere. Nuclear is the most expensive in Europe, and it is cheapest in Asia. So the first observation is we've got large differences in the levelized cost of electricity for nuclear power generation across different regions of the world. Second observation is that we have nuclear being slightly cheaper than coal and natural gas in North America. It is slightly more expensive in Europe. It is hugely cheaper, much cheaper in Asia than it is than are the competitive fuels. So the competitiveness of nuclear with fossil fuels seems to vary by geography, which is interesting. Then if we look at the size of the difference between the highest and lowest median cost of nuclear versus the highest and lowest median cost of coal versus the same thing for natural gas, we'll see that the largest difference between highest and lowest is for nuclear in the world. It's the largest and broadest range in the cost. So why is that happening? What's happening really is that in Western nations, there is a political cost that's imposed on the project. And that political cost comes from the regulatory response to accidents that have taken place in the history of the nuclear power program. And they have raised the risk profile. Sorry, I'll switch now. All right, so they've raised the risk profile and they have raised the cost of nuclear power generation. You can think of the differences between Asia and Western Europe and North America and the differences in the cost as really the cost of the social license in North America and Western Europe. New build nuclear project finance, because of this, has been studied considerably in the US by MIT, Congressional Budget Office, and by a number of other studies, including the OECD. And they all come down to the same conclusion, which is that it is not commercially viable on its own without government subsidy and government risk absorption. The reason for that is uncertainty. It's the regulatory intensity that has come about as a result of nuclear accidents has created a significant burden on projects. And what happens is you get heavier regulatory burdens being imposed on the project. It's followed by the development of first-of-a-kind new technology to meet the requirements of the new regulatory standards. When you bring about first-of-a-kind technology, you get surprises in the behavior of your technologies. Those surprises then are not welcomed by regulators who expect you to be able to predict with great certainty how the technology will behave on commissioning, which then creates delays, which then loses credibility for the industry, which then brings higher regulatory scrutiny. And what that's done to us is created two kinds of failures for nuclear projects. The first kind of failure has been non-completion, which has become a significant risk for any party that's looking at financing a nuclear power plant. And what we're talking about here is the prospect that one might invest billions of dollars in the construction and commissioning of a nuclear power plant and then have that plant never produce any electricity because you get engaged into a difficult cycle, usually on the regulatory end in the course of commissioning, where it becomes uneconomical and where there is not a party that can absorb the risk, certainly to the extent that's required. And we've got many examples of projects that failed in this way. Tucha 2 in Argentina went for 25 years after an investment of billions of dollars, not completed. They've just recently revived it and completed it. You've got in the US, there were the Babcock and Wilcox plants of Belafonte that had $6 billion spent on them. They never produced a kilowatt of electricity. Bataan, which was a Westinghouse plant in the Philippines, it was the Philippines' largest national debt for 30 years that they had to pay off, never produced any electricity. And there was a Russian plant in Cuba as well. But what's surprising is how many examples there are in the world, as you see on the screen, of nuclear power plants that were constructed but never used to produce electricity because they ran aground with this risk of non-completion. The second kind of risk that is inherent in these nuclear projects is, as Mr. Popov referred to earlier, is the risk of schedule overrun and cost overrun. And just to put it in perspective, in the US program, the difference between the time for licensing, the time between license application and construction completion before 3 Mile Island and after 3 Mile Island is this. Before 3 Mile Island, you put your license application in and you could count on completing your nuclear plant within 5 years. Interestingly, that's exactly what the Koreans count on in their domestic program, and it's not far off the mark of what the Chinese can count on in their domestic program. And you'll recall that's a program where the price of nuclear was quite low, or those programs in Asia. After 3 Mile Island, the average time for completion of a nuclear power plant from license application was 12 years. So that difference of 7 years is fatal for a nuclear power project. Because in a nuclear power project, you put all your money in up front. It's a capital investment up front. The operating cost is relatively minor in comparison, as opposed to a gas plant, for example, where the capital investment is lower and the operating cost is higher. And so interest during construction can really kill a project, and has done that to many a project. We've got plenty of examples of projects that have failed in this second way of effectively becoming uneconomic or unattractive economic projects. The most prominent one in the world today is Arriva's project in Finland, which is 10 years over schedule and just about 3 times the original budget. So when you look at that picture, I think you've got to ask yourself, is it really feasible that you can go to the private capital markets and say, as a nation, I don't want to be taking the risk, I don't want to be putting my billions of dollars into this project, why don't you come in and invest your private money in this project? And I think the first question you'll be asked is, well, who's guaranteeing my risk? Who's going to guarantee that the plant will be completed? And how will I get my money back and make a profit? It's extraordinarily difficult, and it's a bit of a problem because in the world today, you have a number of programs that are structuring, I don't want to say they're programs because I'm not sure they are really at the level of programs when they're structuring this way, but they're structuring their hopes for nuclear power on the basis that, as Mr. Popov said, some white knight will come to the rescue as a private investor and absorb the risk on behalf of the program. None of those proposals have managed to work so far. So let me run you very briefly through what I see today as the three models for government engagement with nuclear power. The first model is complete government engagement. That's a pretty simple model. That is the model that you will find in the world's most active and most successful nuclear programs. So Russia, China, India, Korea, the government is completely engaged. The government backs the risk. The government backs the liquidity. And those programs are successful and they are efficient. The second model is complete government disengagement. I think, again, the most prominent example, and it's one that hurts the industry because it's not what it appears to be, is Olkiluoto, where it is said that the government is not engaged in Finland. It is a Mankala model that is privately funded. What we don't spend a lot of time talking about is, in fact, Olkiluoto 3 is backed by a government. It's just not the Finnish government, it's backed by the French government. That's who soaked up the cost overrun on that project. And so again, you've got to step back and ask yourself, is it feasible really to expect that vendors in a world where we've got 70 reactors under construction, 160 planned, 320 proposed, that the vendors of nuclear technology will continue to absorb and soak up the risk for those who want to implement it. Even if they wanted to do that, I just don't see how that's an economically sustainable model. So that leaves us with the third model, which has been adopted largely in two jurisdictions, in the United States and in England, which is a model of partial government involvement, where the government says, I am not signing on very directly for the risk, but what I will do is offer the capital markets, the vendors and the investors, a manner of a hedge for the risk and some incentive to get you engaged. And those programs come in several flavors, and they're not all the same and they're not all successful. So we'll review those for a couple of minutes. I'm going to skip through a few of these. Okay, so let's look at the US example. In the United States, what the government did, recognizing the commercial infeasibility of nuclear power development without government support, which was to implement a very aggressive program to support it. They put in place loan guarantees from the Department of Energy to back the first several projects. They put in place insurance against regulatory delay for cost overrun, and they put in place tax incentives. And in response to that, which all came in the 2005 Energy Act, in response to that, there were 33 proposals in the United States, 33 applications for licenses. Then the Department of Energy said, we want to see two models proceed. One model will be project financed, so it's pure private finance, just like you would do any other infrastructure project. And another model will be where we have what's traditionally been done in North America, which is called rate-based financing. And it basically means that the developer or the owner of the nuclear power plant gets to pass the cost of construction to the public through the price they charge for electricity in a regulated system. And they do that as the project progresses, so they have coverage for their cost and they have coverage for cost overrun. So that's a hedge against the risk of construction delay and cost overrun. So of the 33 projects in the United States, all of them have not proceeded except for two. And the only two that have proceeded have been in jurisdictions that offer the rate-based financing, so that there is a public hedge for the construction delay risk that's passed on through the price of electricity. All of the projects that were based on project finance models have not proceeded and have failed, and in some of them people have walked away from massive investment. I mean, nearly $350 million NRG walked away from in South Texas when they realized that there wasn't going to be any government backing for the completion risk. So in the middle option in the United States, this sort of the government is kind of involved but not fully involved, we see that as between the two flavors of government involvement, the only one that has so far managed to work is where there is a risk hedge offered against that risk of schedule delay and cost overrun. Similarly, the United Kingdom has also attempted to introduce a middle option recently for its program. And in the UK model, what they're doing is creating what's called a CFD, a contract for difference. It's not that complicated a model. Suffice it to say that the basic principle in the model is that they guarantee the price of electricity at a certain level in current day dollars for the life of the project for 40 years to come, which assumes that the main risk that an investor coming into a nuclear power project is facing is the risk of price volatility, which is just not the case. The main risk, as we saw, is twofold. Number one, it's completion risk, and number two, it is that the levelized cost of electricity, at least in Western nations, is higher for nuclear than it is for natural gas. So they're not hedging the completion risk, and they're not hedging the construction risk under the British model. And so my concern for them is, even though they have three very significant proposals that are well underway right now in Hinkley Point, in Horizon, and in NewGen, that they may fail to get a project off the ground if the vendors are not really motivated to get a project across the line and to soak up the risk themselves. And so if I'm to summarize my 3 points for you, they are these. Nuclear projects carry an extraordinary risk, and they cannot succeed and have not succeeded without a government anchoring that risk in order to invite some additional private investment, whether from the vendors or from the private markets. Number two is where the government has sought to implement creative solutions, like there are today many proposals for creative solutions in many of the emerging economies that get the government out of the way of the risk. So far in our history, those projects have not proceeded, and they have failed to generate electricity and build nuclear power plants. And then finally, if one is to design an incentive program, and many today are speaking about modeling themselves after the UK program, as for example in Romania and to some extent in Jordan, you really need to be careful in offering risk hedges. You've got to make sure that you're hedging the correct risk, and the correct risk is the risk of cost overrun and the risk of project delay, rather than hedging market risk, which is, I don't think, is going to be successful in the end. And Mr. Chairman, I think I've kept to my 20 minutes and turn it back over to you.
Thank you very much for your presentation. A very interesting presentation. Colleagues, we suggest that we ask questions after each speaker's presentations. We have enough time to discuss and to debate the issues. Are there any questions? Well, we will have another opportunity to discuss all the presentations that we've heard by the end of our session. And right now I would like to pass the floor to our second speaker, Andrey Korolenko, head of the International Legal Department, joint stock company NIAEP, which is a managing company for Atomstroy Export, the main Russian builder of nuclear power plants abroad. And he will exchange his experience in this area. Thank you very much. Good afternoon, dear colleagues. My presentation will be dedicated to a brief discussion of Kudankulam NPP units 3 and 4 in India. First of all, I would like to note that this is a project with state participation, and The main international public document, which is at the base of this project, is an intergovernmental agreement signed between Russian and Indian governments in 2008. This project is financed by the state, or rather the state provides, or the Russian state provides a sovereign credit, a loan, and this is based on a protocol additional to that agreement that was signed in 2012. So these two documents, which you can see on the screen, is the international legal basis for this project. There are other intergovernmental agreements which can regulate relations between the countries and participants in that project. These are more general agreements, such as the agreement on the peaceful use of nuclear energy, the Convention on Physical Protection of the Nuclear Materials, and other. Like I said, the Intergovernmental Agreement, or IGA, is an instrument of international public law which allows to implement a project on an out-of-competition basis. So there was no bidding procedure, there was no tender procedure. Of course, our company participates in different other projects on a tender basis, like the Timilin project in the Czech Republic. Unfortunately, the tender procedure was cancelled, but many experts thought that the Russian company would have become the winner. And also, another project of that nature is Berlin project in Bulgaria, which was also stopped. The intergovernmental agreement that I mentioned sets forth the main obligations of the parties, that is, of India and of Russia, and sets the basic principles of collaboration. On the Russian side, in accordance with IGA, Russia's obligations is to develop and deliver basic design documentation, to render technical support during installation, startup and commissioning, the design supervision, delivery of equipment, tools, machinery, materials and spares, and also those obligations include sending experts and personnel to the site, consulting service, and other obligations. On the Indian side, the Indian government is obliged to design some building and structures, to obtain the necessary permissions from the authorized agencies in India for the construction and operation, general project management, construction and installation work, and also part of the design work. The Indian side provides living premises and offices for the Russian experts. They operate the units at all construction and operation stages. They're responsible for the physical protection, and according to IGA, they have other secondary obligations. As we can see from the description of the obligations by the parties, our Indian colleagues have undertaken quite a lot of work in the implementation of the project. They're competent enough in NPP construction, and from the very beginning they wanted to share with the Russian side as much as possible, to participate as much as possible in the project. They have been building NPPs since the 1970s, and they are quite competent in construction work, designing. And so this project has been split into the Russian part and the Indian part, which is reflected in the IGA. Further, the protocol that I mentioned, it is a legal basis for providing a loan to the Indian side. This is also an instrument of international public law. I should say that granting a loan is one of the reasons and possibilities for implementing such a big project. And international NPP construction projects are hardly implementable without state support. And to prove that statement, I can say that of all the 9 projects that are being implemented by our company, in many of those we are at a stage of negotiations. There is only one project which is fully financed by the customer, that is Bushehr to the Islamic Republic of Iran. This slide lays out the funding diagram. We do not pay the loan directly to the Indian side. Some of our customers sometimes think that we just transfer the money and then they distribute the money and allot the money to the subcontractors, but that is not so. The Russian state loan is transferred directly to the contractor based on invoices that are approved by the Indian side, including the client. And after the transfer of this money to the Russian contractor, the Indian side owes, so if I may say so, the money to the Russian side, and 15% of the project value is transferred by direct transfer from the Indian customer. As set in the protocol, the Russian side grants the Indian side a state loan or credit in the amount of $3,400 million for financing to up to 85% of the value of each contract, and with the credit in the amount of $800 million for financing of up to 85% of the value of nuclear fuel. As I said, 15% of the money is paid by direct transfer, and also the protocol splits those 15% into 10% as an advance payment and 5% after the award and of each contract. The credit for the construction of the NPP itself, which is called credit number 1, is used by the Indian side in between the years 2012 and 13, and the credit 2 in 2014-2015. Naturally, the amounts of the credits shall be equal to the amounts of the approved invoices for appropriate goods and services. Further, I would like to discuss a part of the project which I call the international private law part, which is in fact a contractual part describing the relationships between the customer and the contractor, and this contractual part which allows to implement this project. The main instrument of private law part is the General Framework Agreement signed in 2014 between JSC Atomstroyexport and Indian organization NPCIL. Both organizations under the IGA have been appointed to be the authorized organization on each side. The purpose for signing the framework agreement, I apologize. The purpose for signing the General Framework Agreement was to create obligations of parties to conclude certain contracts for delivery, services, and design in the future. This arrangement was selected because the Indian side is quite competent in NPP construction, and in this case, the arrangement of EPC contract is not suitable because designing and construction are partially the obligation of the Indian side. Further on, the General Framework Agreement obligates the parties to conclude particular contracts in the future. It determines the subject matter of the contracts, the prices of such contracts, the general modes of payments, deadlines for signing such contracts, bank guarantees, general obligations, and the project schedule. The General Framework Agreement also includes general interaction conditions, or the conditions which will be common and similar in different contracts. And these general conditions are included because these parties want to have a common concept of contractual relationships in the future, and one of such conditions are definitions, changes in the law, licensing, codes and standards, dispute resolution procedure, force majeure, suspension and termination, intellectual property, notifications, governing law, guaranteed parameters of the units, liquidated damages, and subcontractor selection. In conclusion, I would like to say that this arrangement for the project implementation, as splitting it into several contracts, allows to seriously minimize the contractor's risk at the stage of project implementation, because the contractor is not responsible in this case for the delivery of the NPP. The contractor's obligations are split into several contracts, for which of the contracts the obligations are limited, and so this really prevents claims of unacceptable amounts of liquidated damages, and this also is done for diversification, which is one of the basic principles of risk management. That is the overall description. Should you have any questions, I will be ready to answer. Andrey, thank you very much. From your standpoint, how efficient is the minimization of risk, not of the incompletion of construction, through signing an international contract, and would these objectives be achieved if the private operator would conclude a contract directly with if the client would conclude a contract directly with the contractor? Well, in my opinion, a project of that scale can hardly be implemented without the state support, and so the IGA and the protocol on the credit is an international guarantee of a kind. So there are obligations on the Indian side which were undertaken by the Indian government to pay back the credit at certain due time, at certain conditions, and with a certain interest. Colleagues, are there any more questions? Yes, you're welcome.
There's a problem of customers and contractors' liabilities. Have you resolved it for this project? Because there were court cases, and I think they've argued against some international contract clauses. Americans were negotiating with the Indians, and how the liability of the contractor question is being resolved. Can you just respond without opening up some classified information? Yes, I haven't unfortunately touched upon this question in my presentation. However, it is described in this interstate contract or agreement. There is a clause that states the customer is an operator at all the stages and is responsible for any nuclear damage inflicted. But the question is quite, well, there's a very fine line. We know that there's an act, a CNDA Act, in place that contradicts some of the lines and some of the articles of the interstate agreement. However, the parties, after very lengthy negotiations, managed to strike a balance and find the perfect wording that found its way into the contract. But the wording itself is confidential. And one more question we can take. Yes, Andrey from Tvel. Which law did you choose for the main construction contract? So under which jurisdiction? The customer law, Indian. Because there has been experience of carrying out projects, blocks 1 and block 1 and block 2, where Indian law was used and administered, and many contracts that were to be signed in this general framework agreement are also in line with an Indian law. For example, we had experience of using certain wordings, and we don't see any risks, at least our party, in this. There's some clauses and sub-clauses that can help us to minimize the risks of applying this law. In particular, we have a dispute clause. For example, if some claims arise on behalf of on an Indian side, the dispute is going to be settled in the Russian territory. So this clause allows us to minimize the risk. And there's some other clauses like this. Yes, thank you.
I'm Kai Kokko from University of Helsinki. I'm a professor of environmental law. And I have seen this Olkiluoto project, and it's very unfortunate in any case. But I think that in Finland we have a very good environmental laws, in the sense that it is not really the reason why it costs 8.5 million euros. Our government tries to save 4 million euros during the new government during the next 4 years. So in small states like Finland, it's impossible to think that government or state give guarantees for nuclear power projects. They are too expensive. So I think the only solution is private money, if it is really seen that it is competitive, if we compare other future solutions for electricity. And I dare to say that Finland is very favorable for nuclear power, in the sense that we have this Mankala principle, for example, which guarantees actually fair price for stock owners of the power plant, lower prices than what is market price for electricity. And we also have limited liability for the nuclear damages, and so on and so on. But still, Olkiluoto project is too expensive. Thank you.
Спасибо большое.
Thank you. And now I'd like to give the floor to the next speaker for today, Mr. Smirnov Ilya Alexandrovich, who is the head of legal of Akuyu Nuclear Company. This is a company that today carries out probably the only project in the world building an NPP on new law bias, and it will operate and it will build the station. And Ilya will share his experience now. Yes, I have it here, the mic. Good afternoon. If India is very well developed in terms of nuclear power, then Turkey is just making its first steps. Although Turkey conceived building a nuclear power plant in the 50s, and the location itself, Akuyu, was chosen and licensed already back in 1976. However, due to several reasons, the construction didn't jump. And today our company, Rosatom, is currently building this station under the interstate agreement. Some general information about the project. The site itself is located on the Mediterranean Sea in the Mersin province, quite far away from various touristic attractions and routes. This territory is not very well economically developed, but this site was chosen because, as regards seismic conditions, it's the safest place in Turkey. And it's been confirmed by the recent investigations we did, specifically for the regulator, and when we prepared a report on the site's characteristics. So the main features of the project are as follows. The power plant will consist of four blocks, AES 2006, so VVER, basically 1200. The total capacity is 4.800 megawatts. First block will be commissioned in 2023. 2023 is actually a significant year for Turkey because they will be celebrating a 100-year anniversary of the Turkish Republic. And let me tell you that on the North Shore, on the Black Sea shore, a second NPP will be built, Sinop by the name, and it's going to be constructed by a French-Japan consortium, a Franco-Japanese consortium, and their commissioning date is also 2023 of the first block. The total cost approximately 20 billion USD, but we expect that if a couple of optimal decisions are made, some design decisions are made, we can reduce this cost down to 10 to 12%. So the main regulating document is an interstate agreement that was signed in May 2010. This slide is a scope of responsibilities and how they're divided between the Russian Federation and the Turkish party under the contract. The left column shows the responsibilities of the project company. The project company is a 100% Turkish legal entity. It's a daughter company of Rosatom, but the main liabilities are borne by the project company because they will build, own and operate the nuclear power plant. The main features of this agreement is that the Turkish party doesn't bear any financial responsibilities and liabilities whatsoever, but for two. First, connection to the grid. It means that the Turkish party has to provide and ensure that this NPP is capable of connecting to the grid when the blocks are delivered and ready for commissioning. And the second thing is that the Turkish party, and namely Tatash, will buy 50% of electricity at a preliminary given price for 15 years. This slide, it might be a little bit difficult to take just by looking at it, but you can see a very tentative project organization structure. Some of the issues are still not finalized, and we still don't know who's going to own them. For example, contracting. In accordance with the interstate agreement, the general customer, the general contractor, is Atomstroy Export. And at the same time, the interstate agreement doesn't really provide for the scope of responsibilities that Atomstroy Export is going to have. And today we are looking at an option when we can really split contracting into several lots, into islands. So today, at this moment, our company has gone for bid competition, and we're negotiating now with our contractor various hydrotechnical constructions, water intake, water discharge, fish protection measures, the quay and the dam. The total price is about $460 million for this part. We hope that in June the negotiations will be over, the contract will be signed, and in a year or so the company will first do the design, and next year the construction is going to start. And we also want to attract the owner's engineer to help us implementing the project, so that they can provide us almost an independent technical audit of the overall scope of design. So this timeline shows various stages of the project. Last year, now we had a significant date, because 3 years after a very thorough work together with the Turkish authorities, on the 1st of December 2014, we adopted an environmental impact assessment survey, and a positive response was given to us. 400 pages is the IAA, and the major task was how to translate it into Turkish, right? Because there was no industry in Turkey, and it means that the language didn't have any terminology to describe various things. That's why we had to agree with the Turkish partners about the glossary. So we had to adopt the glossary, the terminology, the reference list, basically, that will be used in the report. Now we have a positive decision. We have a green light for EIA. There are some organizations that are not very happy about the EIA we've published, for example, the Green, and they went to court and asking to take away this green light, and we expect that in a couple of months the court will make its final ruling. Definitely we expect that this claim will be turned down. Next, this year we hope to hand over the license for construction. Construction usually is, license is reviewed for a long time. There is a Turkish Energy for Atomic, the Turkish Agency for Atomic Energy, TAEG, but it reviews the application in 1 year and a half. So the earlier we hand over the license, the application, the sooner we'll get it. So we hope to get the construction license back by 2017, and the first concrete works, so the first foundation works for the reactor will start in Q4 2017. And commissioning of units and blocks, each unit will be commissioned a year after the previous one. That's the shareholders' equity and the way it looks like. As I said, AQ Nuclear is the Turkish legal entity, 100% Turkish, but all of its shares belong to Russian organizations that are authorized by the Russian party. What does it mean, authorized by the Russian party? So, for an organization to have this status of an authorized one, there has to be a decision from the government of the Russian Federation, and such decision has been granted to 6 legal entities of Russia. So the major shareholder, as you can see at this particular stage, is Rosatom Overseas, OJC, Open Joint Stock Company, 75% almost. That's how many shares it owns. Atomstroy Export, they hold a small share, Rosenergoatom, 22%, and a whole range of others. Intera, by the way, that's the only company that is not a part of the Rosatom structure. And they hold a very tiny share, less than 1%. Shareholders' equity is 6.1 billion Turkish liras. That's how much has been paid for. The equity has been input in monetary ways, and the budget of Russian Federation is used as a source of equity. In the future, we plan to attract yet another investor. In accordance with the interstate agreement, the share of the new equity investor may not exceed 49%. 49. In other words, Russian authorized organizations need to hold always 51%. What are the features of attracting those investors, third-party investors? Any third-party investor has to be approved by the Turkish side in accordance with the clauses of the interstate agreement. Financing of the project. The financing structure of the AQ Nuclear includes 3 main sources. First is the funding from the Russian Federation federal budget, about 3 billion USD, has already been invested since 2011-2015. This year, in January, the shareholders' equity was once again inflated. It was the fourth transaction, the fourth emission. Then we hope to get money from export and crediting agencies, and we want to attract third-party investors, private equity financing, and it's a very serious task because at this moment federal budget is enough to cover 20% of the total financing, of the total volume of financing. We don't yet have enough licenses still, and we still have some time before we get the construction permit. And by the time we get the construction permit, we will need to have significant amounts of money already available in our pocket. The current project status have already been covered by myself, partially. This year we plan to get a site parameters report approved by TAEG. We want to finalize the zoning plans. We want to apply documents for the construction permit to be obtained, and we want to choose the owner's engineer, select the owner's engineer. Now we are discussing. We're still in the negotiations phase with the Tatash company. They will buy the energy. The negotiations are not easy ones, and they last for a long time already in accordance with the interstate agreement. The purchasing contract has to be signed 30 days after the company get license for generation. And we plan to get the generation license by 2017, unless there's some changes made in the legislation before that. So what lessons can be learned from our experience, the experience we've accumulated so far in Turkey? So the basic learning is that Turkey, due to objective reasons, doesn't have a developed nuclear infrastructure, and it was mentioned in the IAEA report. You know, there is an integrated nuclear infrastructure review group in the IAEA, under IAEA, that travels to different countries, the so-called newcomers, and it prepares an analysis of the state of its nuclear infrastructure. And basically what they review is the legislation, whether it's capable of taking some of those projects. So one of the main things they declared is that Turkey needs to adopt a law on nuclear energy and insurance for nuclear damage. At the moment, Turkey is a party to Paris Convention, and no national acts that would specify any other volumes of or any other scope of responsibilities that are different from the Paris Convention are non-existent. So there are no such different national norms and regulations. They have a very interesting situation as far as law enforcement is concerned when carrying out the project, because the interstate agreement states that the project has to be carried out in accordance with the norms of the Turkish Republic. It's a very tiny phrase, and it seems to be quite peaceful, but it conceals a very challenging situation when we came to design and at the beginning of our construction works. So, we understand that there are two laws in Turkey that do not allow us to carry out the project on time and on budget. For example, the law on the development of olive groves. That's the law dating back to 1930s. And this law stipulates that if there's somewhere an olive grove, you have to, or you cannot build any plants, any industries, especially hazardous ones, 3 kilometers away from those zones. The only thing you can build there is oil plants for producing oil from olives. You know, Turkey is a southern country. Olives are everywhere. They're literally everywhere. And olives is a very positive, is a very big income line for the country's budget. So you cannot just avoid this norm of the 30s. And we are not in a position to avoid the norms or to find a loophole in the law. We are here to abide by the law. That's why we initiated changes into this law. And we did this through the Ministry of Energy. And the second law that also requires changes is the shoreline protection law. No electrical generating facilities can be built 100 meters away from the sea. But, in accordance with our plan, one of the energy blocks sits exactly in this zone. So we've initiated this activities, and we hope that by the end of this year these amendments to the law will be adopted. The only thing that delays us now, that is in Turkey on the 7th of July there are going to be elections, new parliament will be elected, new government will sit in power, and until it happens, nothing, no balls will keep rolling. Also, this interstate agreement contains a reference to the future interstate agreements that will be signed and approved to cater for the needs of the current one. For example, removing of nuclear waste, especially of Russian origin. So in the end, if we talk about the role of the state, in this particular project. So in this case, the government was critical. It was playing a very critical role because the lack of nuclear infrastructure and the necessity to introduce amendments to the legislation could not be realized without the government. Signing of new interstate agreements, without which the project was non-existent. Again, it's the function of the government. So the outcome that I can make is without political support, on behalf of the government, both governments actually, Russian and Turkish, it's not possible to carry out this project. Luckily, we see that there is a full support both from the Russian side and from the Turkish side. The leaders of the two states they understand the necessity of doing it, and we believe that political support will serve as the basis and will serve as a stimulus to attract private investments for investing into equity. Inshallah, as they say in Turkey. And in the end, if you permit, we have one we have one movie, we have one advertising reel, and I wanted to show it to you. Unfortunately, it goes without sound, and it's not good without sound, but it's a very nice movie, by the way. It's an AQ advertising, and it stopped circulating just a month ago, I think, or so.
Со звуком, конечно, было бы интереснее.
It would have been much better with sound, but it's still Turkish, in Turkish, so.
Текст.
But basically, they say that it's the new energy for the new Turkey. Liberal translation.
Да, эта рекламная кампания шла по всем каналам.
This was an ad that was shown all over Turkey. There was an advertisement campaign, there were posters in the cities, in the airports, actually everywhere, in the media. Okay, thank you. Thank you very much, in Turkish. Colleagues, are there any questions? Microphone, please. Maybe ladies first.
Question, so you mentioned that there may be private investors to AKU project, and there are other projects that have been project financed at least partially. And from your experience, to what extent can private investors rely on benefits that state support affords the project, like whether the government would give any financial guarantees or other guarantees to private investors or to lenders to such projects? To all panelists who have something to comment on. I think mainly
As for the guarantees, I can say that the state government will provide no guarantees. So we are carrying out this project without any official guarantees, as guarantees are understood by the bank community. May I provide a small comment? We understand actually all the complexity and the risks associated with that project from this point of view of return on investment and from the standpoint of completion, everything that Mr. Abdulaziz was talking about. We are using different forms of construction for NPPs, different arrangements for funding such construction. This is one of the arrangements that we tried to use, because operating NPPs is a business, it's a good business, it's a profitable business, and our next speaker will be speaking about that. We decided to try it. Time will show how successful our decision was.
The state guarantee is the single most important issue that's at play right now in all of these projects. And so the Turkish project, I think, is innovative. I'm looking forward to see it work. We haven't crossed that finish line yet, And frankly, it would be tested if we run into problems. With an inexperienced regulator, there can be delays. I can tell you that in UAE, what is described as a turnkey contract with operators and investment coming in from Korea, almost full funding. What you don't hear about in the public realm very often is that there is a state completion guarantee, which is what backs what the private investors from Korea and the vendors have put in. And no one was going to proceed without it. That project would not have gotten anywhere. The holdup in Romania, which has Cernavodă 3 and 4 to finish and has had it for a very long time, is that the government proposed to proceed without state guarantees. And they've brought in the Chinese investors now in the form of CGN, and the single most contentious issue, again, in the negotiation is the state guarantee. I think it's an issue that can't go away because the risk that we're talking about is political in nature. It's not a technological risk.
You were quite critical of the UK model of the wouldn't really cover any of the key risks, but and I appreciate that it doesn't cover the time risk, but in terms of overruns, isn't that a question of where you pitch the strike price? Because if you set it at the right level, so to speak, then that does seem to cover the overrun risk. And isn't there also a need to cover the price risk, at least in a European market where I don't think anybody has visibility on where the electricity price is going to be 10 years down the road when the project is completed, because of, say, regulatory developments in Europe with focus on renewables and so on, which essentially causes shifts in the supply curve and has pretty significant a significant impact on wholesale prices. So in a sense, on top of the two risks that you mentioned, don't you need to also cover the price risk? And isn't the contract for difference with the strike price actually a pretty good way of dealing with that? Because you do get price stability. I've been involved in discussions on some of these projects, and I at least had the impression that the price risk was key, at least in Europe.
Okay, so the premise in the white paper for the contract for difference is that the levelized cost of electricity is equivalent for a natural gas-based electricity utility and a nuclear utility or a low-carbon utility, and that the risk that's facing the investor and that's holding back private investment is the uncertainty in the recovery over these very long timelines. The problem with that, and John Parsons, who's I think the world's leading nuclear economist at MIT, points it out, the problem with that is the levelized cost of electricity is materially different, and it's materially different because of the project risk. So failing to hedge that project risk, I think, leaves an exposure. And look, it may work in the long run because the vendors are so keen on being seen to build in the United Kingdom that they'll absorb the risk. But the investment decision track record, because every one of these companies is going to come to a point where they will make an investment decision. If we go by the United States investment decision track record, it has not been very good. In fact, it's been dismal, where there has been no backing for that construction risk.
I think that's a fair point. But I think what happened in the UK was that the whole thing was cooked out pre-Fukushima, where the costs were different. Okay, no, I think that's a very good point. I think part of the problem in the UK is that the basic construction was developed where, at least in Europe, the nuclear construction costs were quite different, and they haven't really adjusted it to the new reality in Europe of increasing costs. And then you could say maybe the promoters are willing to absorb the cost because they're keen to build.
We'll have to see. I mean, the story's not finished.
Спасибо большое, коллеги.
Thank you very much, colleagues. Unless there's more questions. Yes, there are? No?
Thank you for the very good presentations. I guess I didn't say it earlier. I just wonder that do you have the same kind of contract with Finland and in India and in Turkey, so that there's going to be intergovernmental agreement about concerning, for example, legislation or nuclear waste?
As for spent fuel and the disposal of nuclear waste, certainly these issues are regulated by international agreements, and these agreements set forth different options related to the fate of spent fuel and the places for the disposition of radioactive waste. And such international agreements have been concluded with all the countries where Rosatom is building, including Finland. And I would also notice here that the technologies that are used in nuclear energy are improved every year, and right now there are technologies for a deep reprocessing of spent fuel, which significantly reduces the amount of nuclear waste, which generally are returned to the country of origin, that is, to the country where the NPP is located. But variations are possible and regulated by international agreements. I can't remember what is the regime with Finland, but probably Konstantin, our next speaker, will be speaking about the construction of a nuclear power plant in Finland, will cover those issues. Our next speaker is Konstantin Kryzhevsky, Director on Corporate and Legal Work at Rosatom Overseas, which is a general contractor for the construction of a nuclear power plant in Finland. I will try to answer the question concerning the Finland having chosen the law which prohibits to remove the spent fuel and nuclear waste out of the country, and it mandates that the waste is disposed of, and there is in the country, and there's also a law which forces players in the nuclear energy market to behave correctly and to dispose of that waste correctly. On the level of Europe, the European Commission and others discussed a plan according to which the European countries will stop disposing of nuclear waste in other countries. Rather than that, they will adopt laws which will make them dispose of nuclear waste in their own territories. There are different economic and political reasons for the European Commission to follow the suit of Finland, but I believe that the countries should develop a national plan and either use the services of the service providers like Rosatom, or dispose of the waste in their own territory and care for the safety of that disposition themselves. As for my presentation about the construction of an NPP in Finland, the country that has a very serious regulator, just like in Turkey, There is a very strong green lobby and the laws are very stringent. I will provide an example. After we signed the contracts, we understood that we will have to remove frogs from the construction site and even to take measures for the only white eagle that nests there to be removed to another location. This is also very serious because this makes participants in projects in the Finnish territory to take serious measures to abide by the requirements of the environmental agencies. There are very serious requirements applied to environmental documents to be developed by the construction company. But there's another feature which makes Finland similar to the previous project, and that is that Finland does not provide state guarantees for the construction or completion of nuclear power plants by the project participants. And I will be speaking about that a bit later because historically, since the 1930s, Finland has had a model of funding major projects by setting up the so-called Mankala companies. Mankala was the first place in Finland where such project was completed, and then that word started to describe a principle, and that principle is based on setting up a pool of market players which, like a cooperative, are responsible for the company, not only the company itself, but the shareholders to bear the risk. And so the risk is vested into a structure related to shareholders' obligations, and the shareholders agree about the future price for electric power because they always have an alternative of pursuing that project or to buy power in the market. In Finland, this is because Finland has a liberalized market of electric power, which has been formed long ago, which connects to a number of Baltic states, which is very well organized and where the prices are very well regulated. There are no state tariffs which will shift the burden of risks on the population. The market is absolutely liberalized. Rosatom came to Hankikivi 1 project. That is the name of the NPP, which is to be built in Kahajoki at the end stage, because the design company that was set up to implement the project was set up in 2006 by a number of shareholders. It was based on Mankala principles, which propose that the shareholders get the power at cost rather than the dividends. In place of the dividends, that initial company, did perform a lot of preparatory work, getting approvals from the municipalities, choosing the site, and in Finland it is necessary to have a decision by the parliament approving the construction of an NPP in a certain territory. And just like in Russia, they had to get that approval twice, even after Rosatom came into the project, and they had to do another environmental research because our power capacity was less than that proposed by Toshiba and Arriva. We had a completely different design,
the power or the capacity was their power or proposed power was 1700. We proposed 1200. The project proposed funding by the technology vendors. That was the entry condition set by the Finnish partners. The project supposed participation in the capital, and the only attempt to find an investor who could participate in the capital and do the project, that was an attempt to involve a major German energy company, but after Germany cancelled all nuclear projects, they went out of the project and their place was inherited by Rosatom. The first basic legally binding agreement, though a framework agreement, project development agreement, was concluded in May 2013, and it regulated the principles of the future contracts and the principle of negotiation, concluding these then you can see some milestones in the project when major contracts were signed, those the shareholders agreements, the fuel supply agreement, the servicing term sheet that would regulate Rosatom future services, and also the contract, an EPC contract, a turnkey contract, which Rosatom will be performing. The transaction was concluded next year after long negotiations and after buying 34% of Fennovoima company shares. Then the shareholders made their final commitments concerning their funding of Fennovoima. Then there was another decision by the parliament approving the project, and the majority, overwhelming majority, voted in favor. Alongside with that, the Parliamentary Economic Commission set a limitation according to which the Finnish investors should be a majority of 60% in Fennovoima. They set that condition, and they limited Rosatom ability to increase its share in the construction of one unit. We expect that the next stage will be the submittance of documents to obtain a construction license, which needs a serious interaction with STUK, which is the Finnish regulator, and that is the most serious regulator in the area of nuclear energy in the world, in our experience. This is a picture when we are signing the contract in the morning in December 2013. My face is there, and the contract was signed, continuing our bargaining with the Finnish colleagues. In the morning, we agreed, that very morning, after a night of heated negotiations, we agree. The Finnish negotiators are the most difficult negotiators in my experience because of their mentality. The Finns like to agree once and forever, and Russians agree about something, then they amend the agreements, then they like to add to the agreements, and that always must be taken, must be paid attention to in any country. So this is the map where we're planning to build. This is in the north of Finland. We'll have to do a lot of underwater work to blow up rocks. The project has been on for a time. All the preparatory work on this site
is being already performed jointly with the design company. But in any project, the more questions you have, the further you go, the more questions you have, and the more difficult it is. Rosatom in this project is a technology vendor, and that is IS 2006 project. We are also organizing the loan and equity funding, and the Finnvoim undertook to unconditional, irrevocable commitment from shareholders to contribute to the equity. They do not fund the loans. Last December, we approved a subordinated loan from the National Prosperity Fund, and this year that money has come into the project. We have set up a subsidiary in Finland for tax and other considerations, so that we have an opportunity to sell power in the Finnish market later. Like in many projects, there is a certain share of demand localized in the Finnish territory, and probably there will be service companies, Finnish service companies, that will be performing work on the site, and that also relates to the turbine, the control system, but the nuclear island and the design is a Rosatom project, and in that sense, which was done in Russia, which was designed in Russia, needs a license, which is a very important piece of work for us, and we understand all the complexity of requirements applied to us. Nevertheless, it's a positive thing that this is not the first Rosatom project in Finland. Soviet Union built in the past the Loviisa NPP, operated by Fortum. Now that was a different design, but nevertheless it is a reference project for us, because there are still people who passed on that knowledge in our industry to us, and that helped.
At the next slide you can see the overall contract structure. Voima is the Finnish entity established by Rosatom overseas for the project implementation. We belong to Atomenergoprom and Rosatom. They are the main shareholders. So what we do is we can realize some of the contracts by attracting other servicing companies such as 12, for example, and we can order and we can commission other companies such as design bureaus and R&D feed and whatever. And an interesting point in here that when we did some direct negotiations, because the company that implements this project on the Finnish side is not a governmentally owned, it's not a state-owned, it's a private one. So we never had to sign any typical form of a contract. We never had to participate in a tender. So we could agree in a much more flexible way about the terms and conditions of the contract. And in this project, Rosatom overseas managed to agree right from the very start. And I think it was an innovation of a sort. Managed to agree about the early works agreement for the Russian side, and the Finnish side agreed to finance some of the feed things and some of the preliminary expenses. And this forum and this initiative is, well, this early works agreement is used by some other partners and in some other markets. Arriva, for example, uses it, and it compensates Rosatom any potential expenses if Rosatom was not to be chosen as the main contractor. And it also provided for certain payment for certain cost allocation, which is a sort of an innovation. Next slide shows you the overall shareholder structure. That's the Finnish partner, Finna Voima, a design company. It's a very difficult name. In Russian, it's called Voimasaketio. Sorry for not pronouncing it right. I definitely didn't pronounce it right. But as it is known, it's not the first experience for Finns to build this kind of facilities with this kind of model. What interesting is that there are many shareholders participating in the project. I don't want to compare it with the garage cooperative. Such an entity existed in the Soviet Russian past. But let me guarantee you that there are various companies of this sort. For example, Valio, right? They are a potential consumer of this energy, and there are some other shareholders, such as traders, resellers, industrial players. Mainly those partners and mainly those companies that consume lots of energy. So that's a consortium, right? And they've agreed using certain principles on how to finance the projects, and they had will to believe in Rosatom and gave us the money. And definitely it requires a very good governance for such sort of a structure, because it's really important how the decisions are being made and how the future electricity is distributed among the shareholders and how they earn money on this electricity. Let me speak a little bit off topic. Now, previously we spoke about the fact that the success of an NPP project is mainly defined whether the government is interfering or is engaged, and if it is a vendor and guarantees certain costs. But in this project we have a little different kind of a guarantee. We have guarantees from one of the shareholders who is also a vendor of the technologies. And this project is not unique, because the whole market, the whole EPC market, the whole EPC tendering market has significantly changed, and it turned into BOO projects, where vendors really share the risks. They share the risks with the customer. So the projects we've spoken of, some of them were already touched upon, such as Hinkley Point in the UK, the Finnish projects, Mankala model, right? The French projects. It's based on long-term contracts, Exeltium. These long-term contracts serve as a security mainly. And there's some purely Rosatom projects, which you won't, and you probably haven't seen before. These are mainly state export financing structure, when the credit is given by the Ministry of Finance of Russia, Bangladesh, or whatever. And then this credit is used for financing construction or any other works that you will agree on. My colleagues will probably agree with me that not a single nuclear power plant project was ever implemented based on the project financing structure. But the requirements of the states now, the newcomers who want to build something, they really want to get financial proposals from their vendors, from their investors. And I think that a very interesting publication was made by IAEA in 2014. And in this publication, they looked at a trend, at how such big projects turn into different models of contracting. So what's a Mankala model, actually? So a Mankala model is a very interesting, but a very Finnish way of implementing projects. It's when you transfer risks of budget overspend and investment returns from design company to its shareholders. It's an implicit guarantee for financing bodies and structures. When a shareholder has trust into a certain price, it can be used. When there are guarantees from participants of the project, it can be used. And some shareholders will get the energy based on the pricing conditions that is not going to be higher than a certain price. Usually they use forecasted prices based on the cost models, and this financial model is usually acceptable for the market participants and the shareholders. And if they believe that this price is not going to be higher than that, they will use this model. So this model suggests that there should be a legal entity, a limited liability company that is not profit generating. It's making zero profit because it has to pass energy to the shareholders based on the cost. The shareholders are already earning money if they want. If they got this energy cheaper than the market and they sell it to the market, they pre-consume this energy cheaper than the market can give it to them, they are the winners. And how much energy they get depending on their share in the capital and the equity. And they don't pay taxes, what's interesting. And it's interesting because it only applies to Finland. This model has been tested through several court cases in Finland in the 60s. And it was not considered a concealed dividend, but it was considered as a form of getting, instead of dividends, a product. So it's basically a product sharing agreement. This product is tax deductible. You don't have to pay tax from this product. And this model is not a regulated governmental model, it's not a regulated state model. This model is a case-by-case model, right? It's based on the contracting procedures, and the state doesn't give any guarantees, any securities. They just say that there is a certain tax-deductible share of energy that you get instead of your dividends, right? But it requires the shareholders to cover all the costs, be them variable or fixed, and all the expenses of the company, and it creates a certain cushion. This equity finance, and the credit bodies need to have this cushion. They want to have a cushion that's going to be contributed to by various shareholders, and there are many terms of shareholders agreements that limit or do not allow shareholders to leave the society, this community, or how newcomers can enter this consortium, what kind of payments they need to make, and it also stipulates the time during which you cannot exit the model, and it's a contracting model actually, but it has a very serious implementation practice and a long-standing implementation practice, and that's why it guarantees forecastability of such kind of relations. No one is going to do any Mankala project or any Mankala model that's going to be far away from what's been done by other companies or without any consideration of the previous experience. And the rights are, they have no time, no time tag, right? So all the shareholders have full ownership of the energy for all the time of operation. And it's a certain hedge, right? Because the investors are given a guarantee that this energy will go to them and will flow to them. And it's not a short-term right, it's a long-term right, or even an eternal right, so to say. We've already told you that Mankala was already carried out by many companies in Finland in the past. And the tax legislation was fixed for this, and the court cases have also proven that it's workable and viable. There's some conditions that make this Mankala model more stable, because it's a certain partnership between the buyers and the sellers, right? And everybody's interested for this project to jump, for this project to become successful. Everybody's interested in getting the product out of it. So it's a natural hedge. That's actually guaranteed by the structure of the shareholders themselves. Municipal entities in Finland cannot go bankrupt, right? And since this model includes those municipal entities, it ensures its stability. However, municipalities participate in the project only partially, but since the majority of the municipalities participating in the project are basically located in the north, and in the north they really need the energy, mainly they are the main Mankala partners or Mankala shareholders. Next. Now let me give you another example. Olkiluoto. Because it's a different project, but it's also based on Mankala principle. Why it is different? When the agreement was signed for Olkiluoto, Fortum was participating as the state-owned company. And Fortum was quite a significant and quite an important player in here. And it covered a very large chunk of costs in this project. But at the same time, what are the benefits of Mankala structures? Well, the benefits of the Mankala structures can be treated by Western companies and Western markets as not advantages but disadvantages. We know about some of them saying, some of the financial structures saying that since Mankala is not known in the West, you cannot really attract the Western institutions, financing institutions, because you always have to justify every time, you always have to prove that this is a specific, though it is a specific Finnish structure and it works there, it wasn't used before, right? And nobody else in the world uses it. And the Mankala structure really depends on how various participants can agree between themselves and how they will fix in the charter or in the shareholders' agreement their relations. And it's also a risk. Mankala chains consist of other Mankala chains, and it really intensifies and it really aggravates analytics for banks and external financing parties. Mankala structure is mainly there to control the volatility of pricing rather than the volatility of completion, because it doesn't really guarantee the completion itself, this Mankala structure. And banks, they're really going to be in doubt because there's no default procedures, there's no court cases for bankruptcy procedures, but Mankala structure is used because other infrastructure projects in Finland have been using it. And it has a track record, a positive track record. Moreover, Mankala companies, they include publicly owned companies, public companies, sorry, here. They have certain liabilities and obligations in the capital markets. So corporate governance is really a key issue in here, and no one from the public company, from the public companies wants to be a part of the project that's going to default. Probably the financial support of the shareholders is the main thing in the Mankala structure, because they provide irrevocable liabilities. And these irrevocable liabilities are not just contracts signed by the board or the director, right? But these are serious things. It requires some serious work. The participants of Mankala companies, they conduct shareholders meetings, and during the shareholders meetings they adopt full package of agreements and contracts, not just a shareholders agreement, right? They approve the whole package of documents, of the overall financial models. Without that, they're not going to take any financing decision, and not a single shareholders will jump and tap into the project. Very often the shareholders meetings include the public can attend, some experts attend, analytics are there, so the things that they're discussing, it's very thoroughly analyzed and very thoroughly discussed. The only thing or fact that I would like to mention here in relation to Mankala structure is there is also one risk that was checked by the courts in Finland back in the time. They were trying to test whether there was such a danger when, if you have buyers and sellers in the same structure, and this structure has certain rules of the game, has certain corporate governance, will it really lead to any unfair competition? Will it actually lead to any vertical or horizontal integration, which is banned in the market? Of course, there is some certain positive effect for the market, because when you join such companies in a pool, when you join them for implementing capital-intensive projects, there are some benefits, and there is a protection. But as regards antitrust law, court rulings of Finland have confirmed that Mankala structures do not violate the antitrust law. Various claims of Finnish MEPs to European Commission about the fact that Mankala is violating some other rules of the EU law on competition, state support, and so on and so forth. Again, all these claims and all these charges, well, they didn't become a threat. The claims were revoked, and still these questions and these claims are analyzed. And in the end, what I would like to say is, naturally, such a structure will never mitigate all the risks, including the completion risks. But the way these Mancala structures build a project, the way they select partners, and the way they're carefully selecting partners, I think speak for the fact that, and it's been mentioned by an IAEA report, that this model is really interesting in other jurisdictions, and probably we'll soon see a combination of Mancala models with others, or we'll see an import of Mancala models to other markets where similar problems exist, like in Finland. Thank you. Thank you. Konstantin? Any questions? Yes, please. Good afternoon. You've talked a lot about political risks when you build an NPP, because all the projects are lengthy, cost-intensive, and very often you don't have any state guarantees for the projects. So, how these political risks are hedged by companies? Well, imagine some environmental regulations change. Imagine the political way of the country changes. For example, you've been building a nuclear power plant for 5 years, and then in 5 years you cannot use it because the environmental policy changed. You've spent the money is there, it's investment, but the investment goes frozen. Not a single speaker told anything about this situation. Can you please answer that, please? Can I try? Because partially we've mitigated those political risks with contracts and some other tools such as an insurance. The insurance is not something that's used quite often in the Russian nuclear industry, but let me give you a very simple example. When you sign an APC contract, you agree on the list of requirements that exist on the date of signing, or on any other date that we've agreed about. In case the regulation changes, sometimes even for more beneficial conditions, for example, material adverse government acts, that's a concept in Egypt. These are regulations that lead to a different material or outcome of the company that implements the project. So, using these clauses, using the contract, we say that if the norms have changed, as opposed to what we had when we signed the contract, the customer bears all the risk for it. He has to pay for the variations, for things that led to additional costs and expenses. Either the customer pays or we renegotiate if it changes. Now, if we're talking about this material adverse governmental acts, well, you can't really leave the contract as a... you can leave the contract, and that's a remedy, or you can renegotiate the contract. But it's easier to leave the contract because it's hard to agree them. Now, as for the shareholders' agreements, there are some other instruments and tools in the shareholders' agreement structure. In the Turkish option, changes in environmental regulations cannot even be viewed as a force majeure. We don't even know how to ensure the situation. And the customer, well, formally it's a Turkish company, that's 100% belongs to Rosatom. And Turkey decided to go away from the whole contract, and I will still have to consider the political risk that it's a NATO country, and any political lobby will make it only worse for us. We, of course, can go to international courts and we'll try to agree there, but there is not a mechanism of hedging this risk. Or is there? I can't say that there's a remedy for everything, but there's some lessons. And in a couple of countries, when we tap into their markets, the first thing we do is analyzing their regulatory practice, their regulations, and their legal framework. And after that, we try to change the legislation if something is not okay with us, together with our partners, and we usually find support for that. We try to change and amend and bend the legislation so that the country is more ready to take us on board. And in a couple of countries we've managed to succeed, by the way.
Well, it's normal that environmental legislation is becoming stricter and stricter all the time, and it is normal trend. So it is so that strict norms, strict standards, it is not problem for companies. We have studied mining companies, and this is not problem if compliance is flexible enough, so that companies have enough time to adapt new standards. So usually companies which have influence on or effects on environment, it is normal to see that there will be the stricter norms. So when we start talking about the political risks, it is if there is fast amendments, in a sense that they're going to be strict standards and very short compliance times. But I think in generally the idea is that we use permits which allow enough time to compliance, and it is also our recommendation as a researchers that this kind of approach is sensible, and it is also good for competitiveness of the companies in different countries. So it is one possible way to avoid these political risks. I think this is a reasonable approach, and this kind of approach is more and more common, especially in Western countries. So I hope this helps. Yes.
If I may, I'll start with a comment that addresses two comments that were made before, and then I'll have a question for Konstantin. Here is the anatomy of the catastrophic failure I showed you on the slides. So those projects that were abandoned because they couldn't be completed, here's what happens. Something unexpected occurs on the project. Usually it's a technological glitch that was not predicted because you have new technology or you had some poor project management. The response from the regulator is behavior. It's not law. It's not that the environmental law has a problem. It's that the degree of conservatism that's applied in the response then determines the pace of play and determines the burden. And it is typically the case that regulators are compelled, because of the environment we live in at that time, to establish new standards, some of which are revisions to your physical plant. If you're an engineer that's built a plant, you're in an impossible position. So given that, the uncertainty that's been predicted by the Congressional Budget Office on a budget for a nuclear power plant in the West is 400%. So if your budget is $1, you don't know whether you're going to spend 5 or 1. For you to hedge that risk with a market price adjustment, like the CFDs in the UK or like the Menkala model, what you need to be able to do is create a risk absorption capacity that will far exceed the market risk. What you're really doing is looking to a market mechanism to hedge your construction risk. In the long run, if you look at averaging that, if you run the mathematical models, that's a very inefficient way of hedging the market risk, because you always have to predict high on the uncertainty rather than hedging the actual cost as it emerges. So when you look at what the French did in Olkiluoto 3, they got permission from the European Commission in advance to provide a guarantee for Arev's obligations, including the completion obligations. So you had a fixed price contract, so shareholders are very comfortable in a Menkala model, and the French government soaked up and the risk, and then my good friends, the litigators, are making tons of money in arbitrations all over Europe to sort that out. So my question to Konstantin is this: in this model that is modified, if the project should happen to be significantly over budget, twice the budget, 3 times the budget, and it overwhelms the risk absorption capacity of the shareholders, what happens? What's the outcome?
I think the example is that they will continue, because they have Olkiluoto, which is the parties suing each other, but they still going forward. And I think that that's the reason shareholders will take anyway, because it's easy to stop it somewhere at the start. It's quite hard to have some cost and to stop in the middle. So the cost will be higher, but if there is a prospect of completion, if it's not impossible at all, so then I think that the vendor and the other party should find some solution how to split the losses between them.
Есть еще вопросы, коллеги?
Are there any more questions? Well then, we have exhausted our agenda, and on behalf of the panelists I will summarize the results of our discussion. And the first conclusion that I want to make, based on the presentations that we saw and heard, that is that major infrastructural projects, energy projects in particular, and certainly that includes construction of NPPs, have a better chance for successful implementation if there is state funding. I think that's an obvious fact, which is quite obvious for everyone. Secondly, my second conclusion is that the success of the project is defined by the flexibility of the contractor and customer and their ability to increase budget, because practice shows that no project is within the initial budget, and again we need state guarantees there that allow the budget to be more flexible. And the third conclusion is that the implementation of major projects like construction of NPPs is in principle impossible without an active support by the state, by the government. And we see example of that in the amendment of legislation on new environmental standards and regulations. And actually, everything very much depends on the interest by the state in the completion of the project and their willingness to support it. I think we've exhausted the agenda. I would like to thank the organizers of the forum for an opportunity to speak for the members of our panels. I thank the panelists for finding the time and possibility to speak here. I thank the guests of today's session for their patience and the questions they asked, and I wish you all great success at this forum. There will be a little drink, and that is the most exciting part of the program for today. Thank you.